not be a risk even inside the hotel, for example, if patrons are allowed to get intoxicated, that they may really seriously injure another patron by getting into a fight?
Very, very much so. There's, of course, risks associated with serving alcohol to patrons, and there are many risks. However, at this stage, the appellants assert that the issue is whether it is analogous to the present cases. So in the current situation, the incident occurred outside of the bar. It did not occur inside. And this is a key distinguishing factor when looking at whether the current case fits into an existing category. Furthermore, Mr. Briggs testified at trial that he had consumed alcohol, but as the trial judge stated, and the appeal judge confirmed, quote, "There is no evidence that the alleged inebriation among the crowd on the mall contributed in any way to the incident in question. Moreover, there is a dearth of evidence that the inebriation of either Mr. Donaldson or his assailant was a factor," end quote. So in addition to the fact that Mr. Briggs was footbound and was not driving a motor vehicle, there's also no evidence to suggest that intoxication was a factor. Both Stewart and in Manow versus Jordan House, this was a key factor in those decisions and the establishment of those duties of care. The appellants assert that this is an important case. I think that is evident to everybody, that has wide-ranging repercussions on society. We're talking about establishing a duty of care for alcohol-serving establishments to all third parties who may be injured by intoxicated patrons who leave their establishment. For this reason, the appellants feel that it is necessary to proceed, at the very least, with the ANS test. Stewart versus Petty. The ANS test was summarized by the Supreme Court in Cooper versus Hobart. The first branch of the ANS test requires establishing that the harm to the plaintiff was foreseeable and that there is sufficient proximity between the plaintiff and the defendant to warrant establishing a prima facie duty of care. The second branch of the ANS test allows for the contemplation of residual policy considerations that should negativize the establishment of a duty of care for reasons not directly related to the relationship between the parties. Well, the appellants assert that the incident was not foreseeable because there have been no previous incidents at Oktoberfest in past years. We're willing to concede this point. However, as was stated in Cooper versus Hobart, as it pertained to Donahue versus Stevenson, quote, "Henceforth, liability would lie for negligence in circumstances where a reasonable person would have viewed the harm as foreseeable. However, foreseeability alone is not enough. There must be a close and direct relationship of proximity and neighborhood," end quote. If there are no further questions at this point, I would like to turn the floor over to my co-counsel, Mr. David Turner, who will discuss why the appellants assert that even if the court feels that the incident was foreseeable, that there's insufficient proximity between the appellants and the respondents to warrant imposing a duty of care, as well as there are policy considerations that need to be considered that suggest that a duty of care should not be imposed on the appellants.
I just have one minor question. When you're talking about foreseeability, must it be the harm itself? Because you simply assert here that it wasn't foreseeable. Is it not generally foreseeable that someone who is intoxicated may injure someone? They could just take a bottle of beer, break it, use it as a weapon. How finite must it be, or how fine-tuned must the foreseeability be at this stage of the test?
Well, the answer to that question is simple. It is that it does not have to be a specific harm, but rather some harm. So we do not have to look at why or whether it is foreseeable that Mr. Briggs would hit Mr. Donaldson in the face with a glass beer mug. However, it's simply such as Mr. Donaldson. For this reason, the appellants are willing to concede this point with this incident, or an incident like this, be foreseeable.
Thank you, that clarifies.
Thank you very much for your time.
Justice Saron, Justice Hackman, Justice Smith. Good evening, and thank you for the opportunity to make arguments before you today. My name is David Turner, and like my co-counsel, I also act for the appellants. I will present two arguments today. First, I will continue the application of branch 1 of the ANS test and seek to establish that proximity is not established in this case, and thus no prima facie duty of care should be found. Second, I will address branch 2 of the ANS test and argue that the appellants argue that there are policy considerations sufficient to negate any prima facie duty of care should one be found to arise. In Childs, the court analyzed proximity of a novel duty of care. That reasoning will guide the appellant's argument. In Childs, which is tab 5 in your book of authorities, I would draw your attention to paragraph 24. In paragraph 24, Chief Justice McLaughlin clarifies the requirements of proximity as it pertains to the ANS test. Quote, applying the first stage of the ANS test requires, as noted above, an examination of the relationship between the parties to determine what is the requirement for proximity. The law of negligence not only considers the plaintiff's loss, but explains why it is just and fair to impose the cost of that loss onto the particular defendant before the court. The proximity requirement captures this two-sided face of negligence. Chief Justice McLaughlin here emphasizes the importance of the relationship between the defendant and the plaintiff. This is consistent with the long-standing approach to negligence law, dating back over 70 years to Donahue and Stevenson. Yes?
I suppose I have a question in face. I didn't have a question, but now I'm You mentioned Donahue and Stevenson, which is who is my neighbor. It seems to me that the other patron who's in the hotel is a lot closer than the other one who's on the highway who may encounter this intoxicated person. So I have a bit of difficulty with your contention that there's no proximity here and the relationship isn't close enough.
Certainly. So if we look at what the relationship we are actually discussing in this case, it is that between the owner of a alcohol serving establishment and a third party, as you said, who is not the user of the highway. In this particular case, our third person in question, the respondent, happens to have been a patron at their facility. That said, there was nothing particular about the facts of this case that made that relevant. The person who was injured was outside of the particular facility on the street, and that person could have been a third party at a neighboring establishment, or perhaps at the Grey Cup football game that was also ending at the same time.
Wasn't the injured party also drinking that night?
Correct,
Okay.
they were. The appellants assert, however, that because they were outside of the facility and the contact between the two was not related to their mutual presence at the Oktoberfest event, that person could have been any third party. Further, the concern is that the duty being imposed is not that the owner of a alcohol serving establishment owes a duty to its patrons. We're okay with that. In fact, that already exists per Jordan, Menno and Jordan. Rather, we're asserting, as the trial judge and the appeal judge have called it, it is a duty to all third persons who are not users of the highway, not just to their patrons who may encounter their other patrons.
So if it happened inside